This is the Northern Ireland.
Okay, I declare the meeting open, and can I welcome members to our committee meeting this morning. In the room with me I have Paul Frew, Stephen Dunn, Andy Allen and Ciara Ferguson, and on Zoom we don't have any members as yet have come on to Zoom. So I'll start the meeting then with apologies. Our Vice Chair Kelly Armstrong has sent through to let us know that she will be joining us, though she will be slightly late. I don't have any other apologies. Are there any other apologies you know of? Okay. At this stage then, can I ask anybody who needs to declare an interest to do it at this stage? Andy, do you need to declare an interest?
I probably do, Chair. I'm just getting the agenda up.
Oh, sure, you can, well, if you do along the road, we'll take it then.
Charity Trustee, Chair.
Charity Trustee, thank you very much. Okay, members, can I then move you on to agenda item 2, which is Chairperson's business. Members, we've previously made inquiries about the High Street voucher scheme. Just to update you on this, the clerk to the Committee of the Economy has updated us on that some people will receive their cards this week, which will be a minimum of 8 to 12 days after they have applied. However, the Department for the Economy has also worked on the assumption that it would take a number of weeks to validate, process, manufacture and distribute up to 1.5 million cards. The remaining cards are scheduled to be issued over the next 4 weeks. Members, any comments on that or content to note at this stage? Content to note? Yeah, okay. Members, then, just to highlight that our call for evidence and views on the private tenancies bill opened on Tuesday and will close on the 29th of October. We've received an email yesterday from the committee team reminding us of the Minister's reception to mark the success of local athletes who competed in the recent Olympic and Paralympic Games in Tokyo. The event will be held on Wednesday the 13th of October at 6 p.m. in the Great Hall. Members really do need to confirm your attendance with this because of the regulations that they need to know numbers. I know some members have already got back to Antoinette to let them know, but those that haven't and do want to attend, please do let Antoinette know. Okay, moving on then to agenda item 3, which is draft minutes. You'll find the minutes for the 30th of September 2021 at page 6. Can I ask members, are you agreed with the minutes as drafted? Can I get an agree, please? Agreed. Thank you. Then we'll move on to agenda item 4, which is matters arising. Members have been provided at page 18 with a departmental response in relation to a minor capital works programme for sport. Sport NI have advised that the 2-week allocated to the application process is proportionate to the programme. There is a dedicated email address for applicants to direct specific queries and are responded to daily and are published on a clarification page on the Sports NI website. Sport NI also ran a webinar to answer any remaining queries that applicants had in relation to the application process, and over 300 applications are in progress and no requests for an extension to the application period have been received. I think that was on the back of last week, and members had queried why it was only a 2-week window for that application for that. But as they've said, no one has asked for an extension. I did actually see an application form for it, and it was a rather short application form, I have to say. It wasn't too detailed. So, members, any comments they want to make on that, or are they content to note this? Content to note? Okay. Yep. All right, we're going to move on then to agenda item 5, which is Betting, Gaming, Lotteries and Amusements Amendment Bill. That, for me, is a real tongue twister every time I say that. So we'll maybe just call it the Gambling Bill. Members, you've been provided at page 21 with draft questions for the public call for evidence on the bill. If members have any comments, or if they are content with... Sorry, have you any comments, or are you content with that as drafted? It's on page 21 of your pack. Content? Okay. In your table papers, you've been provided with a draft list of potential witnesses for the oral evidence sessions on this bill. The list is fairly long, and as it stands, it covers all of the key areas. Are members content that the committee team work from this list to schedule oral evidence sessions, and we discuss this again in due course if we feel the need to prioritise further? Members okay with that? Yes? Yep. Somebody tell me they're okay?
Yep. Thank you. Thank you.
Thank you. Okay. Sorry, Fra, that's Kelly's seat with the screen there, sorry. Okay, where are we here? Okay. In your table papers, you've also been provided with a draft signposting ad for the call for evidence on the Betting, Gaming, Lotteries and Amusements Amendment Bill. Members, it's planned at this stage that the call for evidence will go out week beginning the 18th of October and a closing date of the 12th of November. Provides the same time frame for replies as we provided for the private tenancy bill. Again, any comments? Are you content to note that? Content to note? Yep. Thank you. Moving on to agenda item 6, which is then the Charities bill. Members have been provided at page 30 with a letter from Mr Chuen in relation to briefing the committee. Mr Chuen advises that he was unable to brief at today's meeting on medical advice, but has asked that the committee takes his views into account. Members, have we any comments? Are you content to note that also? Content to note?
Yep.
Members, you've also been provided at page 32 with a summary of the evidence provided by the 3 individuals that were due to brief the committee. You'll find that at page 32. That's that also. Okay, members, we're going to then move into our first evidence session, which is really quick today. So can we ask then that Mr Crawford be brought into the spotlight? So members, if you turn to agenda item 7, which is a briefing by Robert Crawford on the Charities bill, you've been provided with a copy of the briefing paper, which you'll find at page 39. Mr Crawford, you're very welcome to the meeting today. We have your papers here in front of us that you submitted. Can I ask you then to brief the committee? You have a maximum of 5 minutes. Go ahead.
Thank you, Chair, and thank you, members, for the invitation to provide oral evidence. The points I'll make today are based on my experience of the Commission's investigation of the Disabled Police Officers Association, NI, DPANI for short, and I'm currently a trustee on 2 charity boards. First, a general point. The Minister says that there's no public consultation on this bill because it's a technical bill. It's not a simple technical fix. The briefing to the Minister from officials on the 22nd of January 2020 stated it is recommended that option 2, an amendment to give express power to staff without retrospective effect, is pursued, as it would be much less controversial and would mean that staff could take decisions going forward. Later in June, officials advised any such proposal should be evidenced by a short, focused consultation. Clearly things have changed. Moving to specifically on clause 1, charities unlawfully registered obviously don't want it to go through the lengthy process again. I've set out in my main submission how that could be fixed without primary legislation, or even if primary legislation is necessary, without retrospection. The Commission could simply approve a list of the charities it proposes to re-register. All those that were previously registered unlawfully will have already completed the requirements under the 2008 Act. It seems there's no reason why they shouldn't do that, indeed shouldn't already have done it. On Clause 1's application to the investigative and regulatory decisions, the Ulster Society of Chartered Accountants Charity Sector Specialist Group raised the issue of unintended consequences. The Department admits it hasn't looked at this because it says that, and this was in the letter from Sharon Russell, that no formal assessment was made by the Department of whether individual decisions were unlawful on other grounds. The Commission's use of information gathering powers provides a very good example of how things can be difficult. In the High Court, the Commission provided a detailed breakdown of the decisions, orders, consents, etc. affected by the judgment. The breakdown shows that the Commission used Section 23, one of the information gathering powers, unlawfully 86 times, and another information gathering power, Section 22.3, unlawfully 95 times, 181 decisions in total. We don't know whether any of these powers gathered in personal data or how many people were affected by that, but neither does the Department know this, so there's no real knowledge of how impactful these powers were when they were used, or indeed how the bill will affect them. Details of the Commission's use of Section 23 in the DPANI case are set out in my main submission in some detail. The Commission used the power to obtain DPANI members' personal files from the office, and over 140 files were in the office. The Commission did not inform those whose files were taken. I should update my submission by saying that a leading Northern Ireland law firm has now sent a pre-action protocol letter to the Commission on behalf of over 30 DPANI members claiming damages for misuse of private information, breach of the GDPR and the Data Protection Act 2018, and breaches of Articles 2 and 8 of the ECHR. In case it's thought that this is just ancient history from an old inquiry, the Commission still holds personal information, notwithstanding its statutory inquiries and legal actions have ended. On the 16th of April this year, it wrote to me saying that it intended to retain your personal data in line with its retention schedule. That retention schedule states the Commission will retain information in most cases for 5 years and possibly as long as 10 years. The independent review of charity regulation, you would think, would inform the position for the Department because that review is required to provide an assessment of the delivery of the regulatory framework to date, including the effectiveness of the current regulator in delivering on its agreed objectives and statutory functions. And that looks all very well. But the panel's terms of reference won't let it examine the past decisions which are the problem. The panel's chair stated in the letter that I've passed to you, I would draw your attention to Article 2.1, that's in the terms of reference, which specifically prohibits the panel from revisiting past decisions in individual cases. She also goes on to state that it would not be the intention of the panel to trespass upon its, which is the Commission's, jurisdiction. And it's a bit hard, I think, for the layperson to see how reviewing CCNI's performance, as the panel is set up to do, might be considered a trespass. Moving to Clause 2, on the future delegation of powers to staff, this is a clear change of policy. It's not a technical amendment. The Court of Appeal found no evidence in the 2008 Act papers of any policy intention to delegate power to staff, and a briefing to the Minister on this in May 2020 stated a full public consultation would be required due to the nature of any change which would require primary legislation. There are 2 points I think I want to make on the clause itself. The first is delegation necessary in terms of the workload of the Commission? Madam Justice McBride at one point referred to the Commission's workload as modest. From 2011 to 2019, registration decisions averaged around 72 per month, and casework decisions averaged around 12 13 a month. The Commission has set up a committee, a Schedule 1 committee, it calls it, and that's been recently meeting twice a month. So are we saying that 36 registration decisions and 6 regulatory decisions at each meeting is too much for the Commissioners? That's a question the Department hasn't attempted to answer. It said nothing at all about the workload of the Commission. Delegating registration to staff is another option with suitable safeguards, of course. And if that were done, that would leave just a tiny number of decisions to be taken by Commissioners, 12, 13 a month. The briefing to the Minister in May 2020 stated the AG reflected that the NI Judiciary would be of the view that staff should not be making decisions, although he was not averse to staff making registration decisions provided the test to be passed was made explicit in legislation. I think that could be given some weight, since it's the Attorney General referred to there had been involved for 5 years in opposing the Charity Commission in various legislative proceedings, or various legal proceedings. And the second issue I want to raise is that of governance and behaviour of staff more generally. You've been provided, I think, previously with the Jonathan Baum report, in which he's very critical of the oversight by the Department, referring to a lack of critical oversight and criticising the Department for simply accepting the Commission's account of events, even where that was, as he says, obviously nonsense. The Department has a bad record at governance, and I think even its internal review in 2016 accepted there were failings. It's failed to investigate serious complaints, and it's also failed to use its power under the MSFM to intervene. Approval of the bill might actually look as if the Assembly were condoning some serious misconduct by staff. And the seriousness of some complaints is acknowledged by the Chief Commissioner himself, who suggests in the other letter I provided you with that some complaints should be a matter for a trial court under the Perjury Act. Well, she's a lawyer and I'm not, but I have no reason to disagree with her point of view. The independent panel, as we've noted, will not consider past decisions, and the Council who carried out the Commission's own review of complaints was not permitted to examine these most serious complaints. His terms of reference stated, the independent Council's review will not include providing verification of statements sworn by individuals in the course of legal proceedings. Now, I don't want to get into any of the detail, but Council has now produced the draft report some time ago, apparently in July. That's been circulated to Commissioners and staff, and they're said to be fact-checking the draft. So the people against whom the complaints were made are being given the opportunity to suggest amendments to the independent report by Council. Again, I think I would suggest overall in general, there hasn't really been a proper examination of the criticisms, complaints, concerns about the Charity Commission's actions. That hasn't happened. And until that does happen, and until perhaps the committee and the Assembly can have confidence in the department's governance of the Charity Commission, then it would seem to be rather unwise to delegate powers to staff when there's no certainty that similar problems won't arise in the future. On clause 3, I have little to say on that. I don't have a view on what the threshold should be if some charities are to be taken out of the requirement to be registered. I do agree with the general principle that smaller charities should have a lighter burden in terms of their compliance with reporting requirements. That would seem sensible. A lot of small charities do struggle with that. That's it, Chair. I hope I haven't overrun the time by too much. And again, thank you for the opportunity to provide briefing. Happy to try to answer any questions that the committee may have.
Thank you. Thanks, Robert. No, you didn't run over time at all. You did well. Can I just remind you when you're answering any questions not to refer to any officials by name? Just to point out.
Apologies, Chair.
No, not a problem. I suppose through reading through your submission, the worry of unintended consequences, which is a worry that we always have when we look at any bill that we're doing, we have to look at the unintended consequences. And I know just if you could just maybe just go into some more detail on what you believe would be the unintended consequences should this bill pursue in its current format.
Well, I've mentioned the information gathering powers because of the Commission and how they were used, because they are the most obvious and perhaps the most commonly used powers of the Commission. And in that case, the Department currently has no idea how many people would have been affected by the information gathering powers. Section 22(3) can't even be appealed. There is no appeal for it in the 2008 Act at all. So if it were made lawful, or the uses of it were made lawful by the bill, then the refreshed appeal rights wouldn't apply, because they only recreate the appeal rights that already existed. So someone who currently is thinking of perhaps challenging the Department's use of Section 22(3) would be denied that opportunity. And the Department, there's no sign the Department's thought of that. Section 23 is a difficulty as well, because in Section 23, the only people who can bring a challenge against the use of that power are the persons to whom the order was directed. In the Depani case, the order was directed to 2 of the trustees that had just recently been appointed by the Commission. It wasn't sent to the board of the charity at all. It wasn't sent to the charity solicitors. A copy of it was only provided some months later after pressure was put on in the charity tribunal. And the people whose personal data were taken weren't actually informed that their data had been taken until actually relatively recently. So there's a whole possibility out there that a lot of people who have been affected by the information gathering powers of the Commission might not actually know that they've been affected. They may not know that their data has been taken, and they may be unaware that they have an opportunity to challenge that. It's not actually about the opportunity to challenge, it's more about knowing what's been done with your personal data, where it went, who used it, and all the things that are supposed to be respected by government organisations. No. That's just information gathering. I should say there are other areas there too. I mean, use Section 24 is another potential minefield, because the Charity Commission did share information with a large number of people. That Section 24 is not going to be covered by the bill. So if, for example, the Charity Commission shared information, as in a number of cases has, with employers or with the police or with any other regulatory body, or indeed with funders, then the charities and the individuals may have suffered a detriment as a result of that. And one of the things that certainly has happened is that charities have lost, that have been subject to investigation, have lost funds and have lost funding opportunities. So none of those things have been really tested by the Department. I mean, I'm only familiar with a small number of inquiry activities. There are many more of those decisions out there that I know nothing about, but neither does the Department. Okay,
Robert, thank you for answering that. If I could move you on then to the clause 2 and the delegation of powers, and we know, because we'd heard from a representative from the Scottish government about how they use their delegation of powers. Just again, if you can, and I know that you've personal experience of this as well, and I don't want you to touch on that, but just explain to us just in a bit more detail again your concerns around this delegation of powers.
I think my concern, first of all, let me say I'm not actually in principle against the idea that staff should take some decisions. What's important is that they take them properly. And what's important also is that there's proper management and proper governance around that, so that basically they're not able to take decisions that are going to create difficulties and problems for charities without having had those decisions properly scrutinised at an appropriate level. The bill kind of tries to deal with that by exempting certain decisions. I don't think that's really the right approach. I think the difficulty certainly I've found with the Charity Commission is it tends to go in very hard and very aggressively. And it's very difficult for charities then to deal with that. Now, if those powers are to be exercised by staff without proper governance and without proper management supervision, then that creates a real difficulty. And that's why I highlight those issues in my submission. Can I give it just one example? I mean, I find it hard to believe, for example, that a board of commissioners, and particularly a legal commissioner, would actually countenance the use of a Section 23 power to enter premises when their correct power to be used for that is Section 52 in the Act, which would require the Commission to go and get a magistrate's order. Surely a Commission that was exercising its management responsibilities would have spotted that, not least because the Section 52 power is headed powers of entry. I just give that as an example, close to me, and it's partly the anger and frustration with the misuse of powers and the lack of engagement by the Commission that's led to the legal challenges, and indeed the most recent legal challenge, because people expected the department to take concerns and criticism seriously. And I think there's what I would say is there's those who've been involved in inquiries. There's no confidence in the Commission, and until there is, then I think there's a risk of delegating powers to staff because the governance arrangements just aren't there.
Just on that final point there, where you'd said about the lack of confidence in the Commission, how do we address that in your? I don't know if you have an answer to that or not. How's that
I do, Chair, and I'm very glad you asked the question, because I think you'll see some of it in the recommendations that I've made. I mean, I think first of all there has to be proper independent examination, investigation of the complaints, concerns and criticisms that are raised. That's what the NI Ombudsman's guidance says there should be, but it hasn't actually happened. The simple test question for the department is, who is the investigating officer and where is the investigating report? In my case, I put in a whistleblowing complaint, and then there was a much larger complaint put in by various Depani trustees and so on. And the whistleblowing complaint was not dealt with as part of in accordance with the whistleblowing guidance. And the larger complaint ran into the sand a bit because the Assembly disappeared but was never properly investigated. So I think that's the starting point. Start with looking at what's gone wrong, and that's not about punishing people, unless, of course, something's found that justifies that. It's about finding out what went wrong, and then after that, coming up with proposals to fix it. There are a number of minor proposals in the department's own internal review, which didn't look at the past decisions. That was in 2016, but none of those things were ever really properly implemented, it seems to me, and I think that's where we start. There must be a proper investigation. I think it's surprising and perhaps a bit concerning that the independent panel, which is carrying out the current review of charity regulation, is actually prohibited from looking at those past decisions. Because how can it possibly report on the Charity Commission's performance without looking at all the things that were the subject of complaint? That seems to me like stacking the deck in favour of the Commission. And again, you see that, as I've said, the Commission's own review by Council doesn't look at some of the most serious concerns. So that's where it starts, Chair. I think that's where you start. Then you come up with proposals to fix the underpinning governance and management concerns. And then only after that do you think about, well, what does charity regulation in the future look like?
Well, thanks for that, Robert, and you preempted my last question to you. Was I going to ask you around the independent review, charity regulation and the independent council review, and I know that you'd raised issues of that it will not deal fully with the issues that it needs to deal with, yeah, I think that's not good. So it isn't that you've highlighted that. and it isn't good either that there is that lack of confidence by some within the charitable sector within in the Charity Commission. Can I ask members if they want to indicate if they want to ask any questions of Robert? Yeah, go ahead, Paul.
Yes, Robert, thank you very much for your presentation. It's good to have you here. If I could take you through just the clauses, it's a short enough bill, but it seems to me to be quite impactful, and of course we know the history of everything that's went on. I've read it somewhere, if I can find it now, I've read it somewhere there was 8,000 decisions taken in the period that we're talking about retrospection. And I've read it somewhere, I'm not sure if it's your submission or not, I've read it somewhere that 6,800 of them were just simply registrations of charities. Do you know what the remainder of decisions that were taken, what categories they fall into? If they're not registrations of charities, what are they?
I have some information on it. Really, the best document is, I think, a document that was provided to the High Court in June 2014. It came from the Commission's own legal advisor. They were applying for a stay of enforcement of the High Court judgment. And in that, he gave the total of casework decisions as 1,163. Now, that included 63 which were in progress. And registration decisions were given as 6,860. Of which 83 were in progress. Now, he also provided a breakdown of around 270 of the decisions. For example, the figures I quoted in relation to Section 22 and 23, but there were in addition, for example, orders to suspend, there were 14, order to appoint additional trustees, there were 4. Well, actually, there were 5 in the panel alone, so that actually isn't quite right. Order to restrict transactions, which was a very punitive order that was used quite often in 15 cases. But there are 870, 890 decisions which are not itemised in that. Now, if the Commission hasn't still got that document, I'd be more than happy to provide a copy to the committee if that would be helpful. But again, I do think it's not complete. Order to appoint an interim manager, for example, in 9 cases, Charities had an interim manager appointed. Now, there's no information yet as to what happened as a result of those appointments. What did the interim managers do? And that's another very fertile ground for litigation, because actually the charities had to pay for them and the appointments were all illegal. Sorry, I've probably gone off your point.
No. It's all information is gratefully received as much as possible, so that we can get a better understanding of all the concerns and the problems out there. So I take the issue with regards to retrospectability of any bill, and I can see straight off problems with that. So, is there a neat way? I know you have problems. I know you have problems with Clause 1 because of the retrospective nature of it. But is there a neat way to have Clause 1 performing a function of here now, moving into the future, and taking away the retrospective aspect of it? And if there is, what does that look like?
Well, first of all, I think it's Clause 2 actually does provide for the possibility of some decisions being taken by staff in the future. So if it were decided, and again, I think that should be subject to public consultation, that registration decisions in the future might be done by staff with suitable safeguards, and I go back to the point about governance, then that would deal with the vast majority of the decisions and leave only the small number of regulatory decisions to be taken by commissioners. Again, I say, commissioners should be involved in these decisions because they are very impactful in individuals and charities. And with regard to looking backwards on your retrospection point specifically, I don't think there should be a difficulty with the Charity Commission simply listing all of the charities that were on the register unlawfully and approving them at one meeting. All the information that had to be provided by charities is already with the Commission. The advantage of that as well is that that could be done tomorrow. It wouldn't have to wait for the end of the bill, so there's a chance that some charities might actually be able to get into funders who require them to be registered and get some money that they could spend in the current financial year. And to me, I don't know, I just don't understand why the department seems not to have looked at that. there is a bit of a clue, I think, in one of the letters I provided, where it says that looking at a new register of charities would do nothing for the other decisions. Again, I think combined with that would deal with the old registrations that could be made lawful again very quickly. And looking forward, I think there is an important need for proper consultation on exactly how and what safeguards would be provided in relation to delegation of any powers to staff. But I'd make the point that the workload going forward isn't necessarily that great anyway. Commissioners could carry it in the meantime while there was a proper informed consideration. The other thing I would say, sorry in case I forget it, is it's not too late for the independent review to start looking at some of the older cases. To me, that's the neat way of doing it, is that you don't let staff take investigatory decisions because the workload doesn't justify it. But you do look at the possibility of staff taking registration decisions once you've got the proper governance and management controls in place.
So is there anywhere in clause 1, I know you're not legally, and you've already stated that, nor am I, but is there anywhere in clause 1 where it actually, in some of those sub-clauses, actually differentiates between registration and other decisions, in your mind?
Well, clause 1 does exempt certain decisions from the effect, if I understand it rightly. But at the moment, the bill is essentially looking at everything as one block. And one of the points I tried to make in my original submission is that they're very, very different types of decision. Yeah. So it's quite possible to look at them differently. You could, if, for example, you wanted to re-register charities and my proposal that it could be done by the Commission wasn't possible, why not split the bill? Why not create a bill that simply has a list of charities that says these charities shall be registered, shall be placed on the register? That presumably would have little opposition, would go through very quickly, while taking the other decisions and investigation and regulatory powers out of that and putting it through the proper normal public consultation approach. And again, the only bill that hasn't had public consultation since the Assembly came back in the Minister for Communities bailiwick is the coronavirus bill and private tenancy. So that would seem to be a very sensible approach and allow the more controversial decisions to be considered properly, effectively, and in appropriate time. Clause
1, subsection 5 lists out, yep. I think it's six actions basically that are excluded, as far as I can read, yep. That right. Do you see rationale for those 6 being listed out, and also why are they picking? And I have the Charities Bill 2008 up on my internet. Why are they picking sections 33 to 36 and not other sections? What's so important about 33 to 36?
I did. Well, first of all, they are essentially primarily the sections that deal with the inquiries and the powers that are available to the Commission to take action after inquiries have been instituted. They are the most serious powers. The removal of trustees, suspension of trustees, restriction on charities funding, and all of that. My guess, again, I tried to ask the question but didn't get a particularly complete answer. My guess is that they've picked the powers that have already been the subject of legal review and challenge, and they don't want to, if they put them in the bill, then they'll just get more challenges with the refreshed appeal rights. So what they've tried to do, and it's clear when they say they consulted the Attorney General on this, they've picked categories of decision where they think they would be more likely to get challenges, and most probably on human rights grounds.
Just on the fresh appeal rights, subsection 7 A and B, it talks about the relevant action as one mentioned in column 1 of the table in Schedule 3 of the 2008 Act. Now, again, that's a big act, and I'm trying to get through it. So I haven't had sight of column 1 of table in Schedule 3 of the 2008 Act. Can you tell me, if you've seen it, what are those relevant actions? Can you give me some indication as to what they are?
There's a list of relevant actions, and indeed you would find, for example, that what it does is it sets out the decision taken by the Commission. For example, Section 22, the decision to open an inquiry, and that can be challenged, again, by certain people. Section 23 would be listed, all the elements of Section 33, which is the suspension and removal of trustees and so on. All of that is in there. And it's set out in the table because the actual appeal rights are different. For example, the person affected by a suspension order can bring an appeal, so can the charity, if it's the trustee. In relation to Section 23, though, the people who can bring the challenge would be the institution or people that order is made and directed to, not the people who are affected by it. And that's why there's a very lengthy list in there, but in some cases it's a bit strange because there's no challenge at all to Section 22.3, which is the power in the Commission to make a direction to require you to provide information, which can be personal, but that Section 22.3 power is actually, the Commission can ask for information on oath, and you're guilty of a criminal offence if you don't comply. So that schedule and that table is useful up to a point, but it's the kind of an area that you would expect a proper review of charity regulations to look at and say, well, are there problems here? But again, if you want me to go through more of the detail, I will. But that's what it is. And in essence, it is the schedule that sets out this is who has an appeal right. These are the people who can appeal, even if that seems a bit counterintuitive that it doesn't include all the people who are affected.
So again, and I will look it up to have a good look myself. So am I right in saying, and is it fair of me saying, that through this bill, the Department is basically trying to carte blanche all respective decisions that have been taken over the years from a certain date, which is the 16th of May 2019. But at the same time then, in further on the clause, they're actually limiting opportunity to appeal.
Well, I don't know about limiting opportunity to appeal. I think the opportunities to appeal weren't there in some cases, like Section 22.3, but I wouldn't accuse them of that. What I think is that they've started from the point of view of saying, well, how do we get all these decisions, or as many as possible, back into lawful mode? And it's quite clear from the early briefing that wasn't the plan, and the plan has only become that somewhat later, and we don't quite know why. I think what they've done is said, like, okay, we start with wanting to make every decision lawful. Then we took legal advice from the Attorney General and said, well, how do we make sure that this is ECHR approved? How do we make sure that we won't get challenged to death by simply making lawful decisions that were made unlawful by the May 2019 decision in the High Court? And that's where they've come from. And the option has been suggested to them, well, why don't we exclude some of these decisions completely? And that makes the bill very strange, because there's no particular logic in the bill to say why these and why not others. And it's certainly my speculation that these are the ones they've had trouble with, and they know they would get future challenges. So yeah. I don't know if that's answered your question or not. It's just I think the bill is a bit of a mess. I think they've tended to say we want a one-size-fits-all, and they've just reached for the whitewash brush.
Yeah, and I think it's that mess that I'm trying to get my head around, and I'm struggling these last 3 weeks, to be fair. So with regards to all the registrations, so I'll take you back to all the registrations. Is it your sense that it's better to have one big schedule of 6,000 charities on a schedule on the face of a bill, or is it the fact that the Charity Commission, with its new powers, or even with its current powers, can actually have one meeting and declare all those registrations deemed lawful and re-register them in a practical sense in a meeting? Is both of those options viable, and what one's your preferred option?
Well, first, my preferred option is the Charity Commission do the second option, simply because they have already received all the applications and all the information to support those applications when they first registered all those charities. So that work has been done. So what more is required to be done? It seems to me the Commission can simply take the list that was the register as of the whatever date in May it was, the 5th of May, I think, of the High Court decision, and simply say these charities we are now re-registering. Who's going to complain about it? Who's going to object? The other advantage it has is that, unlike the other option of simply having a list of the list of charities in the bill, is that it's quicker. It could be done, relatively quickly, whereas otherwise we would have to wait until the bill goes through. So my first option would be the Commission does it. My second preferred option would be that the bill do it by attaching a schedule of all the charities that are to be replaced, put back onto the charities register. At the end of the day, that's the most important thing that needs to be done. It's the most important thing that people actually agree on. So why not do it by the simplest route?
Okay, thank you very much, Robert, for your time. Thank you.
Thank you.
Okay, any other members want to come in and ask anything? Kelly?
I apologise sincerely, Mr Crawford, for being late to the meeting today. I had other things on, unfortunately, this morning. But you've brought up an interesting point about naming charities on the face of a bill. Can you see that there may be a difficulty? I worked in the community and voluntary sector before I came to being an MLA, and the charities that I worked for amalgamated or changed their name. When that happens, then the bill will contain information that's not correct. So in listing names, would that not cause more problems for those organisations, because they'll be listed on a bill and then the bill isn't correct because you're changing something that needs to be outside of that primary legislation listing and would be then in the Charity Commission list?
I think that's a good point. However, it seemed to me that the way that it would operate is that the bill would place the charity on the register. That's all the bill would do. It wouldn't be that charity in that name in perpetuity. So once the charity is put back onto the register, it would then be subject to the normal management of the register. If its name changed, it would notify the Charity Commission. If it became defunct, the Charity Commission would also be notified by the last remaining trustee. So it seems to me that actually once the bill had done its job of getting the charities back onto the register, the normal register management process could resume.
I'm not sure. I think we'll maybe check with our bills office to see if that's appropriate, because I don't think it happens with bills the way that you believe it does. Once something is on the face of a bill, in order to get it changed, you have to go through change to primary legislation. So while a charity may well change its items if it's listed on a bill, and that is no longer an entity that's in place. So I think as a committee we'll certainly ask that through the bills office and get their guidance on that position, certainly. Yeah.
Okay. All right, thank you, Kelly. No other member has indicated they want to ask any further questions at this stage.
Just on the point that Kelly raised, because I agree with her, and I think that's something we do need to scope out, but I wonder if you have a big listing. I wonder if there's any examples of where there's a big listing in primary legislation, and if there then was a clause that basically future-proofs it. If there's a wording of a clause that can be applied in a general sense that future-proofs it, for name changes and defunct charities. It'd be interesting to explore that, Chair. Thank you.
Certainly we can. Sorry, go ahead, Robert.
Could I just make the one? It just occurs to me that in fact the bill, the effect of that schedule attached to the bill can be time limited. It can have effect, and the bill can say that it will then cease to have effect at a certain date. I mean, I wonder, is there a legislative way around that? But perhaps I should just leave it to the committee to check with the bill's people.
And that's something certainly we will do. We can check that out with the bill office and get more clarification on that. Okay, no other member has indicated that they want to ask anything further. Robert, can I thank you for your submission and also for briefing the committee today. Thank you very much.
Thank you for your time, Chairman members, Chairperson members, and thank you very much for your attention and patience. Thank you.
Thanks, Robert. Bye-bye. Okay, members, we're going to... Sorry, Kelly,
I'm just going to apologise to you, Chair, for lateness today. Sorry about that.
You're all right. I got your email earlier, so it's fine. Okay, members, we're going to move on then to agenda item 8, which is a briefing by Trevor McKee on the Charities Bill. If we could bring Trevor into the spotlight. Members, you'll find this briefing paper is on page 58 of your meeting packs. So therefore, can I then welcome Mr McKee to the meeting this morning? Trevor, you have up to 5 minutes to brief the committee if you want to go ahead.
Thank you, Chair. Members, thank you for having me here today to give you this very short briefing. The Charities Bill, in my view, goes nowhere to address the concerns raised within the Loughnane Rescue Inquiry. In my submissions, I have challenged the proposal to retroactively make decisions pursuant to Section 22.3 lawful. Section 22.3, among other things, can be used to obtain personal data. As the Charity Commission decisions were unlawful, this was a breach of Article 8 of the European Convention. The bill would make these decisions lawful, but unlike other decisions, there would be no refreshed right of appeal, because there is no right to appeal a Section 22.3 order in the Charities Act 2008. The bill clearly impacts on the human rights of those affected. In my second paper, I explained in some detail the legal arguments that the Charity Commission decided not to defend in the Lockney Rescue Challenge to the institution of an inquiry. Though there is no intention to retroactively delegate powers to staff permitting the opening of an inquiry, the Commission still maintain the position that Section 22 inquiries have a presumptive validity. If this view is allowed to prevail, then the Charities Bill is undermined, because there will always be the shadow of incomplete candour and underpinning its existence. This is inconsistent, I say, with the rule of law. Clause 1, Section 6 of the Charities Act 2008 defines the decision makers and their particular skills which they are to deploy when discharging the functions of the Commission, and standing orders of the Commission require that the Commission must act collectively. I say it's a bit of a jump from that requirement to allowing one senior official or a junior official to exercise his powers. Section 6 also gives the Department a duty to appoint commissioners to ensure that they have the right qualifications to discharge their functions, and in tandem with Schedule 1 claims an oversight role of Commission corporate business. Retrospective legislation should be a harbour of last resort, not an administrative convenience, which it seems to me that this bill is. Retrospective criminal legislation is forbidden by Article 7 of the European Convention. Although essentially civil in nature, the charity law and the powers of the Charity Commission can carry criminal consequences. It is therefore, in my view, within the scope, certainly, of Article 7 at least. By making decisions that are not appealable lawful, the bill asks the Assembly, albeit unintentionally, to condone illegality with no redress for the victim. For example, a direction under Section 22.3, and I know that you've discussed this already. The exemptions or carve-out listed in Clause 1.5 ADF are fundamentally necessary to protect the civil rights and lawful obligations of citizens. Many of the Commission's decisions, orders and directions carry criminal penalties, as I've said before. It is essential that these rights are protected from potential abuse. Up to now, the Department does not know exactly what rights are being affected because it hasn't looked at all decisions, just categories of decisions. My suggested amendment is that the making of past decisions lawful is not necessary. Any charity that wishes certainty in its business interests may simply make a fresh application to the Commission, who can then remake the decision via its Schedule 1 committee. Alternatively, the exemptions listed in Clause 1.5 should be extended to at least those which are covered in Section 174 of the Charities Act, which covers orders, etc. That allows the Commission to seek punishment for the offender in the High Court. And these will also include information gathering powers which are subject to sanction under Section 25 of the Act. Clause 2. As per Clause 1, certain challenges to the practices and procedures deployed by the Commission staff have never been subject to proper scrutiny. On each occasion these matters were brought before the Charities Tribunal, the Commission would withdraw its resistance to an appeal or an application, or would seek to avoid scrutiny by challenging appeals as out of time or that the applicant had no standing to bring an appeal. Without examining each of the impugned decisions subjected to retroactive validation, it would be impossible to gauge the impact and consequence to individuals, thereby satisfying the requirement stated in the Court of Appeal that careful consideration should be given to the question of whether any of the powers and functions therein enshrined can properly be discharged by the staff of the Commission. I'm relatively content with the delegation of powers of registration. The Schedule 1 committee in use by the Commission appear to be dispensing its business effectively and economically. However, if registrations were delegated, then some 96% of the Commissioner's workload effectively evaporates. My suggested amendment would be that only registrations are made delegable and not judicial powers, and certainly registrations don't need to be retroactively made lawful. Refreshed appeal rights. It is a matter of some concern that the Charity Tribunal was and is largely unsympathetic to applications made after the time for doing so has expired. I myself was forced at some personal risk to take a decision of the Tribunal to the High Court on this very same ground, and for the High Court to deliver a scathing rebuke to the Tribunal for disallowing my appeal. My suggested amendment is that all decisions, orders, directions that are made retroactively lawful, if they have to be, are made appealable, even if not specifically allowed by Schedule 3, and that the 42-day appeal window was extended to a minimum of 3 months, which is the equivalent for judicial review, to allow affected persons to be alerted to the potential for challenge, first of all, and then to marshal the quite significant resources necessary to initiate the appeal process. And I believe that the Department should liaise with the Department of Justice to ensure that any alterations to the tribunal rules which would allow the extension of the appeal window required are effected in advance of the bill receiving royal assent. I have a supplementary point simply to make that's not about the Charities bill, but it's about charities themselves. And much has been made of the registrations that have been rendered unlawful by the judgment. However, there's a backstory comprising the 3,500 charities that have either been forced to close or simply gave up. I can only authoritatively speak about my own experience and about the town where I live. In our local community centre, both the Pensioners Dinner Club and the Mums and Tots groups have disappeared. Both raised funds annually to provide either a Christmas dinner for the elderly of the estate and the other for after-school snacks for kids in the area. Both funded their activities by receiving small private donations or from bringing by events. Both would have been subject to regulation by the Commission. Both would have been subject to the reporting regime. Neither had the resource or the commitment to be the subject of the restrictions imposed by registration. And this is a scenario that must have been repeated countless times over the 10 years of regulation. And my simple question to the Assembly is, who stands for these clubs? Who stands for these groups? Where's their charities bill and who debates their passing? Thank you, Chair and members, for your time today.
Thank you, Trevor, for that. I have a couple of questions. Justin, can I ask members if they want to ask anything? Can they indicate and let me know? Trevor, your paper states that the retroactive making of past decisions lawful provided in Clause 1 is not necessary, and that any charity can make a fresh application to the Commission who can remake the decision via its Schedule 1 committee. Why do you feel then that the Department has not pursued this method and gone for the proposals in Clause 1 instead? What's your thinking around that?
Seems to be, to me, Chair, to be just a catch-all bill that looks at all of the mistakes and the decisions that the Charity Commission makes and try and deal with them all in one fell swoop. A point that was made there with Mr. Crawford earlier about the retroactive registration of charities, if I can talk about that slightly, because I might explain the position that I'm in with the retroactive aspect of the bill. Since May 2019, the Charities Commission has adopted the process of working through a Schedule 1 committee, which is a lawful way for them to take decisions. They have made charities that were registered prior to the McBride judgment made them charities again. They've retook those decisions. Now, if they can retake those decisions for a small number of charities that were subject to litigation, for example, then it's a simple stretch to not just bring one or two charities to a meeting, but bring a group of charities to the meeting. And I believe a member made this point earlier on. Is that an option to do? Well, yes, it is, because that's exactly what they've already done. So there is no issue, there is no necessity for any retroactive aspect to fix the woes of the Charity Commission. Those processes are all in place at this point in time with the Schedule 1 committee. They don't have to take one decision to re-register a charity. They can take a decision to re-register a number of charities. If we look also at the Scottish experience, whenever they began regulation, for example, they received the deemed list from HMRC, which we have here, the deemed list, which lists all charities or all organisations that are claiming tax exemptions, and then they were simply put on the register. And then as the year went by, as those charities were subject to some sort of scrutiny, then the decision was made, well, actually, you're not a charity, so we're going to remove you from the register, or here's what you need to do to become a proper charity. Being a charity shouldn't have to be a contest. It should be something that's intuitive, that organisations should naturally fall into, and if they don't want to be a charity, then they should be able to opt out from that process. That is logical, and that is fair, and that is proportionate regulation. What we had in Northern Ireland, where we had a contest to get onto the register, where we had stringent requirements imposed on very small charities, then what that did was that simply stripped away the fabric of society. I've spoken about the Pensioners Club and the Mums and Tots. How many of those organisations have simply disappeared, and what impact has that had on local communities? So that brings us to another question, and I don't want to preempt, going forward what it is that we're going to talk about, because the de minimis level is very, very important. But those 3,500 charities, are they simply just forgot about?
Yeah.
Sorry for going on.
No, you're all right, Trevor. I know it's very emotive for you, and you're very passionate about the issue. And I know, and you've mentioned it there about those charities within our local communities, and just the effect that all of this has had on them. It's just to ask then, do you feel that Clause 3 could be amended in any way, then, to make it easier for those smaller charities or groups who do not, who don't wish to be registered?
Of course, there's been no issue. If you look at a jurisdiction like England and Wales, where they have I'm not sure, but I think it's approximately 5 times the amount of charities in England and Wales. They have no issue with having, I think it's the £5,000 threshold, under which you don't have to register. There's no public clamour to have these registered. There's no massive call about abuses or misconduct or mismanagement in these small charities. What it simply does is allows these charities to exist without that regime of regulation. And that regime of regulation is stringent, and it is strict. Up until 2012, before we had registration and before we had a regulator, was there widespread abuse? Was there widespread criminality? Well, bringing the Charities Commission into being didn't stop criminality, because the Charities Commission, as an NDPB, cannot investigate criminality. That always must fall to the PSNI. So, what it seems to me is that we've simply made ourselves busy fools. We've regulated a sector that potentially does not need regulated, and that's a question I don't think has ever been properly debated. Why did we bring this Charities Act and this Charities Bill forward? Is it necessary, or is it simply over-regulation? And I know that's a question for another day, and I know that it's not particularly relevant to the Charities Bill, but the whole Charities question and the regulation of charities is as the appeal court said, a matter of some public potency.
Okay, thank you, Trevor, for that. I'm going to ask if any members want to come in and ask any questions at this stage. Paul?
Yeah, thank you, Chair. Trevor, thanks very much for your attendance here today. I did read your briefing notes. I found it very interesting, actually. I'm only on the committee 3 weeks, so please give me a fool's pardon on some of this stuff. I'm trying to get my head around the bill, and I do see glaring dangers, if that's not too strong a word at this stage, with regards to the retrospectiveness of stuff and any decisions that were taken. Now, I know they do go into detail as to restricting some of those decisions. And we've had, I'm sure you've heard the talk we had with the previous presenter and the debate we had even in the room here about taking away the retrospectiveness of the registrations of charities and doing it another way, either by a commission action in a meeting, in a practical sense, or putting on the face of the bill a schedule that lists out all charities. And just my primitive mind's been thinking about the discussion I had with the Deputy Chair there about how you actually could do that in a practical sense on a face of a bill, and a clause that would make sure that it was only set in a date and a time, and a specific time. And I suppose the question I'll ask you is, would it be feasible in your eyes that all those charities would be listed out in a schedule? And I'm sure the department listening in will be horrified by some of this stuff, but let's tease it out. A big list of charities on a schedule, thousands of them, and then a clause that deems all of those charities registered at a certain specific date and time, that being the 16th of May 2019 or whenever. Do you see that as a practical way forward, or do you think it's not needed? Because quite simply, the Commission can meet and agree wholesale on all the charities that are involved in a practical sense and just deem them all registered.
Well, first of all, I believe that it can be done exactly the way that you've articulated it there. That schedule as such can be brought to a Schedule 1 committee or a meeting of the Commission as a whole, and those charities then simply be deemed to have ticked all the boxes and are validly now re-registered as charities, as they have done already, with a number of different charities retaking those decisions by Schedule 1 committee. So there's no necessity for retrospective legislation to bring those charities back onto the register. The other danger is that you might be bringing onto the register charities that may be excluded further on down the line whenever the de minimis level is set. And the department have said that this is something that they're going to do. So I don't see the point in pushing through a charities bill that's going to register a charity that doesn't need to be registered in the first place. Because many of those charities, and the majority of charities are small charities in Northern Ireland, we're a different jurisdiction from England and Wales. A lot of those charities probably have welcomed the fact that they haven't had to do their annual reporting, that they haven't had to be subject to regulation. And the Charity Commissioner herself on the Nolan Show said that you do not have to be on the register of charities to be a charity. Your governing document makes you a charity, not being on the register of charities. Being on the register of charities just simply allows us to have an oversight of what it is that you do, and that somehow might give confidence to funders, etc. But those funders have been operating and have been discharging their functions for the last 2 years from May 2019. There has been no large public outcry that I have seen. Now, somebody might tell me something different, or somebody might have an alternative opinion, but I do believe that my opinion is valid, that the retrospective registration of charities is not necessary and actually dangerous. Putting them on the face of a bill, I can see the difficulties with that. Time limited might not work. It might not be something that you can do with a statute. That would be something for the Departmental Solicitor's Office. But I think that it should be explored, that and at least discounted if it's not going to work, or simply look at the easy option, which is bring that schedule before the full Board of Commissioners. Are you happy? And if they're happy, re-register them, but with a caveat that quite a substantial number might not want to be registered or might not need to be registered. And don't forget, there's been a small number of aggressive registrations over the years as well, where charities who didn't want to be a charity were forced to become a charity. They were organisations that had charitable purposes but did not exist exclusively to be charities. Didn't want to be on the register but were forced to be on the register. Now, those types of aggressive registrations must be rescinded. I believe. I can't think off the top of my head of an appropriate example, but I'm sure they are out there. But these are things that the department hasn't actually looked at yet. They've looked at the broad panoply of decisions and registrations that require to be done again in their view, but they haven't really sat down and gone through the minutiae. Now, this process that we're going through today, and grateful to be a part of it, But it is entirely necessary that this is extended, and it's not necessary for this bill to go through in this mandate. Charities don't need that reassurance, I don't believe, and nobody has told me to the counter.
Trevor, see when you talk about Section 1 powers, I think you maybe mentioned, or actions that the Commission is currently operating on, what do you mean by Section 1? What does that mean that these decisions are being taken and registration of charities are already taking place?
Schedule 1.
Schedule 1, sorry, Schedule 1.
Schedule 1. A Schedule 1 committee is the upper level of delegation permitted by the Charities Act 2008. The charity commissioners or the charity commission can take decisions in one of two ways. The first way is by a meeting of the full board, and the second way is by delegating powers to an officially authorised Schedule 1 committee. Now, that Schedule 1 committee can be constituted by at least one commissioner and a number of others. Now, there is an argument, and I have a particular view of how that committee should be made up. And the makeup of that committee has changed over the years. The committee that was established post-May 2019 is different from the committee that's actually in situ at this point in time. I believe the committee in situ at this point in time comprises 3 commissioners and no staff. And we can get into the conversation about rubber stamping and if staff can be members of Schedule 1 committee. But that Schedule 1 committee can lawfully take decisions and take registration decisions, and it has done on at least one occasion that I am aware of, and that particular decision was subject to a challenge in the Charity Tribunal.
Can I ask, does the Schedule 1 commission or committee, can that delegate power to individual staff?
No, the Schedule 1 committee is the decision making function of the commissioners. Yep. Delegated to it, but it becomes very dangerous whenever you delegate powers and allow those powers to be sub-delegated again. That brings in another whole raft of difficulties. So decision making should remain with the person with the power to make that decision. If it can be delegated lawfully, then the statute will make clear that it can be delegated lawfully. But sub-delegation is a very dangerous game, I do believe. Now, the scheme of delegation will probably allow that, and I know that the Charity Commission at this point in time have commenced succession training, and succession training is simply a way of instructing members of staff to take certain decisions. I think the question of the scheme of delegation came up in a previous meeting about that will be a power of the department, and that's right and proper because Section 6 of the Act gives the department that power to make alterations to the powers of the Commission. Therefore, it wouldn't be appropriate for the Commission to actually devise that scheme of delegation. But what hasn't been thought about, or what hasn't been talked about up until now, is that the scheme of delegation, regardless of what anybody else has said, has actually been set. Because if you have a schedule of orders, directions and decisions that will be made retrospectively lawful, then those form the scheme of delegation. Because how could you make retrospectively, say, a direction under Section 22.3 retrospectively lawful and then not have it in the scheme of delegation? So it's the department has not looked at that difficulty that is going to arise further on down the line whenever the scheme of delegation is started to be talked about, because any clever lawyer would make mincemeat of a scheme of delegation that didn't reflect the retroactive delegation or the retroactive making lawful of decisions that had already been enshrined in the bill.
Mm-hmm. See, with regards to the delegated powers, you're clear in your statement that you think that it should only be the registration of charities that should be delegated. Is that right? Am I Picking you up right?
You're correct. Yeah, yes, you're correct. But just to qualify that, it's the delegation to staff
Yes.
the power to register a charity in a benign sense, not in an aggressive sense, in a benign sense, that a member of staff could register a charity that has ticked all the boxes, but not retrospectively. Going forward, the Court of Appeal decision wasn't about retrospective legislation, it was about how the Commission might work going forward. So the difficulties that the department are trying to deal with at this point in time is to try and rewrite history. Those things happened. They had practical consequences, and for some individuals they had dire consequences, but you can't erase that. You can't simply lift the carpet and brush that under. Yeah. That is something that has to be exposed, brought into the light and examined. And the Commission have to, at some stage, and I've talked about Section 22 inquiries, they have to at some stage acknowledge that those inquiries up until May 2019 were all unlawful, because simply they weren't, the decisions to institute those inquiries were not taken by the Commission as a corporate body, as a whole body, as a court, at a court meeting, nor through a Schedule 1 committee, because one did not exist prior to May 2019.
That brings me on to my point, because I'm reading Section 22(3) in front of me here with regards to the 2008 Act. Why do you think that they're leaving that section out with regards to the refreshed appeal rights?
Because it's not listed in Schedule 3 of the 2008 Act. Mr. Crawford gave you a bit of an overview of Schedule 3 and the powers that it contains. Put simply, there are a number of decisions, directions and orders of the Charity Commission that are appealable, but there are also a number that aren't appealable, and they're simply not appealable because they're not listed in Schedule 3. So that's an inconsistency that the Department of Justice would need to be involved with, that if a power or if a decision is made retrospectively lawful and that decision has criminal consequences and it is not appealable, then it is inconsistent with the European Convention, because Article 6 gives you the right to a fair trial, and if you don't have the right to a fair trial because the direction that you were given isn't appealable, then you have a difficulty.
So Section 22(3), Section 22 is the General Power to institute inquiries, and then it deems a list of powers, if you like. Is there any other schedules or sections within 2008 that really needs to be on the face of the bill listed out, as has been column 1 of the table in Schedule 3? Is there any other? Well, that Section 22(3) might impact and might have impacted on you, over the years and your experiences. But is there anything other than that we need to be cognizant of as a committee to make sure we get onto the face of the bill?
First and foremost, now, you've started to read the bill and you've started to get to grips with it and come to terms with it. It is a considerable piece of legislation, so it would actually need a lawyer to go through it to determine all of the matters that need to be put in the face of the bill. As a private citizen looking at the bill, Section 174 of the Charities Act 2008 lists a number of orders and decisions of the Charity Commission that can be pursued in the High Court by the Charity Commission if there's a failure to comply with a particular order, direction or decision. So as a minimum, the carve-out that's already listed in Clause 1 needs to be supplemented by Section 174 and Sections 25 of the Act. But there may be many others that I've overlooked. I can only talk about those that I've had some personal experience of, and by no means an expert in the Charities Act 2008 or the Charities Bill. But I do know that there are inconsistencies, glaring inconsistencies, and you've just pointed one out. So, from our own collective look at the Charities Act, myself and you and the committee have already decided that there's at least a question hanging over that particular issue. Is there anything else that needs to be on the face of this bill? Yes, there does, but it's much more than that. Because if the decision-making power in the Charities Act is the commissioners, and their standing orders say that they must act collectively, and they can only lawfully discharge their functions through the Schedule 1 committee, then where's the alterations in the Charities Bill that deals with those amendments that need to be made? If the Charities Act is to be altered in any way, shape or form, then it has to be done all at once and completely. Otherwise, we're going to be in this boat further on down the line. We've already been in it in 2013 with the public benefits test. We're now in it again because of the Charity Commission having misunderstood the law.
Last question for me. You name in your statement that the retrospective making of past decisions lawful is not necessary, as was advised by the Minister's own charity team and the former Attorney General. The necessity to do so only serves to protect the commercial interests of affected law firms. How do you know the Charities team, Minister's own charity team, advised against, and also the former Attorney General?
I believe that was in an FOI release to Mr. Crawford, where the advice given to the Minister at that time was that the retrospective legislation, the Attorney certainly said that retrospective making lawful of decisions of the Charity Commission shouldn't happen. He may have been happy that the registrations went forward, but I believe that Mr. Crawford could probably talk better about this because it was his FOI, but it's certainly my understanding that the Charities team did advise the Minister not to go for retrospective legislation and to be very wary about the delegation of any authority to staff.
Okay.
And because the Court of Appeal was very clear in its warning that any of the powers therein enshrined can properly be discharged by staff.
Okay, thank you very much, Trevor. Can I ask just the committee if we can ask the committee, or if the committee can ask the department to release all Freedom of Information requests and answers on this subject?
Yeah, we can certainly ask for that.
Yeah, I think it'll be interesting to see those.
Okay, thanks, Paul.
Thank you, Trevor.
Thank you, Kelly.
Thank you, Chair, and thank you very much, Mr. McKee. Mr. McKee, as I've said earlier today, I worked in the community and voluntary sector for many years before becoming an MLA. You've said that this piece of legislation doesn't need to go through in this mandate. From my point of view, I don't find that acceptable because a lot of charities then will have no recourse to government funds and therefore they will cease to exist if they can't access grants. Can you understand why it's on the committee's responsibility? This legislation is coming through. We're going through our legal committee stage at this stage. It's not going to stop. So we do have to take this through. Can you understand why many charities are actually waiting patiently for this to happen so that they can be assured they can access government funding? Or other funding?
Well, first of all, as my understanding is that any charity that has any difficulty with making funding applications, seeking funding or receiving funding, that those applications, if they were previously on the register, then the Charities Commission would vouch for the validity of any application, and therefore there should be no restrictions Certainly, there should be no restrictions from money coming from government.
Not necessarily true, Mr McKee, because I do know that there are monies from outside of Northern Ireland that you would not be able to apply for unless you're on the charity register formally, and this is why this legislation is required. I'm interested, just at the final point, I know that Mr Frew has asked a lot of questions, so I'm not going to keep you so long. You've spoken a lot today, and thank you for that. But one of the issues that... I've lost my train of thought now, sorry, Mr McKee. Yes, the appeal process, section that you're talking about. I understand that, and we will certainly as a committee seek information on that, so that those decisions that have been made, for instance, if the Charity Commission through this legislation are able to adopt and say that those registrations that are currently there are accepted, what happens to those who were turned down in the previous regime that is now being fixed? So we can certainly look at that for you. The only thing I would say is that there is a concern that, this seems to be a piece of legislation that is a lot wider than it is. It is exactly what it says in the papers, and we do have to stick to that. My other concern would be the reference you've made to the freedom of information. It is my understanding that legal advice provided to a minister is privileged and is not released, so I'm not 100% certain what that information is. And as Mr Frew has said, I would be very interested to see the responses provided on the freedom of information, because if that contains legal advice received by the minister, that might open a floodgate to a lot of other things Mr McKee have to say, but no, we'd be interested to see what that is. But the Attorney General that you mentioned, I'm not aware that the Attorney General would have provided information to a department. So perhaps if you're speaking to Mr Crawford, we can ensure that that information is sent through to the committee as well, where the Attorney General, the former Attorney General, has put that in writing. But that's all I have. Sorry, Mr McKee.
Okay, thank you.
All right, thank you. There's no other member has indicated that they want to ask anything further. Can I thank you, Trevor, for coming in and briefing us today, and thank you for your submission through to the committee. It certainly have given us a lot of food for thought there, so thank you so much.
Thank you, Chair. Thank you, members.
Okay, thank you.
Chair, sorry.
Sorry, go ahead.
I know we've noted that we're going to write regarding FOI. Would the committee like us to contact Mr Crawford to share his FOI response in the first instance, which might speed that bit up?
Yeah, we'll do that.
Sure.
Yeah. Thank you. Thanks, Janice.
Just
Go ahead, Fran.
a point on the FOI and the contacting the department. Over what time frame are we talking about? Are we talking about this past year? Are we talking about the last 5 years? Are we talking about...
No, I think we get that information off Mr Crawford first and foremost. And then...
Well, of course, the pivotal date here is 16th of May 2019. But we can simply ask the Department of any relevant freedom of information requests and answers to do with charities. And I think that there will not be that many of them, I would think, but let's see what comes up.
I think we have to specify this charities bill, because I know certainly in the past I would have written in freedom of informations about charities. You'll see my name appearing up in my past life.
Okay, well, that would be interesting. Okay, so we'll go to Mr Crawford first, and then we'll follow on from there. Members agreed with that? Okay. Look, members, can I just ask you to take your ease for a few moments while we prepare for our next witness session?
This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room.
Okay, members, we're going to move on to agenda item 9, which is the departmental briefing on the October monitoring round. Members have been provided with a copy of the departmental briefing paper in your table papers. And I am totally have lost what page I'm on. And can I welcome Terry Arnold and Gavin Patrick to the meeting? You're both very welcome to the meeting today. Good to see you again. Can I ask you then to go ahead with your brief?
Okay. Good morning, Chair and Committee, and thank you for the opportunity for myself and my colleague Gavin to brief you today on the Department's 21-22 October monitoring round position. Before I commence today's briefing, I would like to apologise for postponement of last week's briefing and for today's briefing paper only issuing yesterday. Minister had asked officials to further consider and finalise the Department's response to withdrawal of the £20 per week universal credit uplift. This work has informed the Department's monitoring round submission and delayed our briefing until today. I'm aware there have been some changes in committee membership since Gavin and I were last here, so I'll begin by introducing myself. I'm Cherry Arnold, the Director of Finance with responsibility for welfare and employment, and my colleague Gavin Patrick is the Department's Director of Finance with responsibility for engaged communities, housing, urban regeneration, local government and corporate services. In-year monitoring rounds provide departments with a formal system to review spending plans and priorities for the current financial year and provide departments with the opportunity to register any pressures or easements against their budget allocations. We have provided a written briefing which sets out the Department's October monitoring round position. The October monitoring round was commissioned by the Department of Finance on the 31st of August with a submission date of the 1st of October, the outcome of which is subject to executive agreement. Whilst the Department has received COVID funding of £119 million in the current financial year, we have resubmitted a £7 million bid in the monitoring round for local councils. This was a bid which was not met in June monitoring. Local councils have continued to face pressures in the current financial year in respect of lost income and assisting with post-pandemic recovery. The Department has also submitted a bid of £55 million in October monitoring to mitigate withdrawal of the £20 per week universal credit uplift. The Minister has been clear that it is vital this support continues. Subject to executive agreement on this bid, the Department will have a reoccurring requirement of £108 million per year increasing to over 200 million as people are migrated from legacy benefits to universal credit. Work is ongoing within the department to scope the delivery mechanism for the continuation of the uplift, and legislation will also be required. In the monitoring round, the department has notified Department of Finance of a 7.6 million COVID ring-fence resource reduced requirement. This includes 2.7 million of COVID funding for universal credit recruitment. This reduced requirement is largely due to delays in the recruitment of staff to fill universal credit vacancies and associated IT and accommodation costs. NICS-wide recruitment competitions for staff at key management grades of AO2 and AO1 are ongoing. However, whilst over 600 staff have been recruited for universal credit, this is approximately 240 lower than what was forecast in April this year. We've also declared a 0.5 million COVID easement in respect of Northern Ireland Housing Executive supporting people provider personal protective equipment. This is due to expenditure being lower than anticipated. In the monitoring round, the department has also notified Department of Finance of 15.5 million of other ring-fence resource reduced requirements. This includes 8 million on housing benefit rates for owner-occupiers, due to the current forecast of rates rebates scheme benefit spent by Land and Property Services being lower than expected, and 5.5 million in relation to welfare reform, 4 million of which has been due to lower than expected contract costs and 1 million due to delays in filling staff vacancies. In the monitoring round, the department's also submitted 2 million of welfare mitigations reduced requirement. This is largely due to delays in progressing legislation to close the benefit cap and social sector size criteria or bedroom tax mitigation loopholes, which restricts access to these schemes. The department's also surrendering a 1.1 million reduced requirement on financial transactions capital as a result of applications for Housing First type projects not materialising as anticipated. The department has also returned a 1 million ring-fenced non-cash DEL easement related to impairment costs as a result of a deferred start date on the New Lodge Urban Renewal Area Scheme. In light of the unprecedented increase in wholesale energy prices, a UK government announcement of 500 million to provide support for vulnerable households over winter, the Minister has asked for options to be urgently considered. The department has notified DOF of the work being undertaken to consider options in order to bid to provide some form of assistance to mitigate the higher impacts of higher fuel costs on vulnerable people. Any funding allocations will be a matter for the Executive. The department's 21-22 AMI forecast expenditure position on social security benefits and pensions remains at 7.3 billion, with no material changes since June monitoring. In completing the monitoring round, we have sought to ensure the department is in a position to live within strict tolerances and that appropriate funding is in place to meet business needs. At this stage of the year, requirements are based on the best information available. However, due to the nature of our operating environment, with continued impacts from the pandemic and economic uncertainties, the department's requirements are liable to change. As such, the department has used this opportunity to reposition its budget as best it can. I hope you found our briefing today informative, and Gavin and I are happy to take any questions.
Thank you, Cherry, for that. Normally we would have something to say about the lateness of getting this and also the postponement by a week, but I think given the fact that the universal credit uplift has been included in the bid allows for that to happen. So it's good to see it there. I just want to ask you a couple of questions on that. I know that a bid for 55 million has been put in the document here, but is that, what about the total cost? Because we know that it's going to require some sort of system of paying, if it is agreed, some sort of system to pay that money out. And we also have staff costs on top of that. Have you any indication at this stage what actually the total figure for that might be?
We don't. Unfortunately, we're still undertaking scope and work within the department to determine the delivery mechanism. We have notified DOF that if required, a further bid for all the associated costs, including the IT and staff, will be submitted in the January monitoring round.
No, because I mean, this, we all know, everybody in this committee knows that this cannot be, there's not some sort of magic wand can be waved around and this happens next week. We know that it takes much longer than that. We know that there's planning involved in that, and there has to be some sort of scheme set up, and that will have added costs. So it would be interesting then to get those added costs whenever you know what those costs are going to be. I wanted to then ask you around the fuel poverty part at the end there of your submission, and the possible uplift there. Are you able to tell us now at the minute, would that be through the winter fuel payment? Would that be an added amount on top of the winter fuel payment, or are you looking at a different type of scheme there also?
There's a range of options that's currently being considered, and we've notified DOF of that. At this point in time, a decision, however, has not been taken, and that would be delivered.
Okay, well then that would be interesting to get that information as well as to just how that, because we know that you know, whether it's going to be what way it's going to be means tested and who is going to receive any extra money. So it would be useful if the committee is kept up to date on those issues as well. Can I then just move over to a couple of other issues? You mentioned there about the 7 million bid for local councils. Are you able to tell us any? I know that you have worked very closely with local councils over the last year and a half, certainly on their finances. If this bid cannot be met, what is the real-time effects that could have on our local councils? Have you been appraised of that?
If I take that question, Chair.
Yep.
Excuse me. So councils received £10 million for COVID funding in June monitoring, and at this point work's ongoing alongside the councils to determine the exact need. So I don't have any further information at this point other than work is ongoing, and as you say, we've worked closely with councils throughout the pandemic and will continue to do so.
Thanks for that, Gavin. I mean, it's been a little while since we have had Solace in front of us to brief the committee on just how councils are managing, so that might be something that we need to look at as well, because we don't want to see them falling behind either, albeit I know that a lot of their income streams have opened again, which is good news. But with the issue around rates, I would imagine they are still finding it difficult. I just want to ask you on page 29 to do with the financial transactions capital and the increasing housing options and the money that is being handed back there. Can you give us a bit of an indication as to why that didn't materialise and any impact that might have on housing going forward?
So the initial budget was the estimate of need in the year. It relates to a project to buy approximately 15 houses for homeless people who are unsuitable for temporary accommodation, and some who will have had addictions or mental health issues. The business case is currently being prepared, and in light of that draft business case, the total needs 1.5 million, which allowed the easement then to be given up as part of October monitoring.
Okay, and how far are we behind on that? Because I know I chair the All-Party Group on Homelessness, and Ciara and I attended the meeting yesterday, and we know the pressures that our third sector are under, especially with the supporting people budget and the no uplift in that. So it's just what's the time scale on that, because this is an urgency.
I've been advised that we're confident that it will be completed within this year, a business case and the spend to take that forward for the remaining 1.5 million that has been held by the department.
Okay, so if we could maybe then just get further information on that as well, just a bit of a breakdown on the timeline of where we are there, whether that's from yourself, Gavin, or from the department in general, as to where that is. I think that is something that we need to keep on top of. Members, can you indicate if you want to come in and ask any questions of Kelly, and then Andy? Kelly, go ahead.
Thank you very much, Chair, and thank you very much, Chair and Gavin. Here we are again. I've a few questions, if you could bear with me. The first one's probably going to be a quick one, so we'll get that out of the way very first. Chair, you had mentioned there about, under the welfare reform piece, that you talked about the contract costs. Could you just break down what those contract costs were?
It was in relation to welfare reform contract costs for PIP, independent assessor.
Oh, right, okay. No. Yeah, no, that's great. Thank you very much. I wanted to ask you about the COVID uplift and the 55 million. I know that we had in the chamber, we've discussed this, and the Minister, rightly so, brought it to attention that there may be issues about computer issues and so on. And as the Chair has asked, if we could see the full cost, that would be wonderful. I'm a bit concerned, is the 55 million okay? Because I'm very aware furlough has just come to an end, and we may see people who are working through the process of being made redundant. So they won't necessarily be signing up for universal credit in October, but it could well be in November or December or even January. If they're joining universal credit and they are added into the network of people who will need the £20 per week uplift, will we have enough money for that?
The £55 million uplift was obviously based on the caseload for universal credit as at May, and every month there's obviously onflows and offlows. There will be a period of time for obviously the legislation to be in place and for this to be operationalised. The legislation won't, however, be retrospective. We have, however, notified DOF of the fact that this bid at this point in time could change. So they are aware there's potential there for this bid to be higher or lower.
Okay, thank you very much. I know what you mean about your figures could be liable to change. My goodness, I don't envy you on that one. So it does allow for wiggle room for people who join universal credit at the end of furlough who are perhaps being made unemployed. You've said then that the amount being surrendered, or easements, is just over £23 million. I'm just wondering, Westminster had announced support for workers, that 500 million, and there's the potential then, now I know it's unhypothecated, Barnett consequentials coming across of about 14 million. The 23 million plus, if we were able to get that 14 million for communities, would go a long way to making that £55 million COVID uplift. I'm assuming you guys are putting in the bid for that money?
For the 14 million,
yeah.
The 14 million was for support over winter for vulnerable households. Yeah. So it fits with fuel. But again, as I mentioned, we have notified DOF of our plans to bid. Okay. Dependent on the options that are determined to deliver, a mitigation to support people over winter with the rise in fuel prices.
I'm very aware at this moment in time that we are looking ahead at long last, hopefully, to multi-year budgets. And obviously this COVID uplift, now it is a COVID uplift, it's directly related to COVID. If the Minister is fortunate and gets that allocation, it will take us through to the end of the financial year. Is the department started, or have you started to look at what the consequences would be post-March and the costs for that? I know you've the mention of the 110 million, 108, 110 million pounds going forward, but given the fact that it's tied in with COVID, just thinking about the welfare mitigations piece that's due to come forward, I take it that's all being counted into budget considerations for going forward?
It is, and we're collating those at this point in time, obviously to inform the future year's budgets. Obviously, we're aware that DOF are commissioning. It'll be a 3-year exercise in terms of our resource and our capital requirements. So we're collating all that information at this point in time, and that will include our requirements on a range of issues, including the universal £20 uplift and again future mitigations.
Yeah, no, thank you very much for that. I just want to make sure that we don't miss the boat on the future budget, because it is 3 years. Want to get in on the ground floor on that one, if that is the way that we're going forward. So thank you for that. My final question, thank you for your patience. We've heard about the £15 million that's been allocated to social housing to deal with... Oh, sorry, I have 2 questions. Sorry, apologies, Chair. I forgot one, Chair. Do we know if we get the money for the £55 million, if that payment to claimants will be discounted from their benefits that they're receiving through Westminster?
I'm not sure on that position at this point in time. It'll obviously have to be something that's considered as the legislation's drafted.
No, thank you very much. I know that probably would be outside of yours, but then my final one, finally, Cherry, sorry. The £15 million for social housing for the increased construction costs. I welcome it because I know the problems that the building industry are having with timber and so many of their construction costs going up. It's not mentioned in this paper. I'm assuming that that's already okay and the department has the figures for that and you don't have to bid for that through the monitoring round.
Kelly, yes, that's correct. That's from internal reallocations on our capital budget from other easements, from delayed projects, etc. So at this point, we're saying it's up to £15 million, and we haven't had to bid for it.
No, thank you very much for that. That's really helpful. As always, guys, I appreciate the work that you're doing, and it hasn't been an easy time, and I think it's not going to be an easy time going forward, but thank you very much.
Okay, thanks, Kelly. I have Andy, Mark, Paul and Fred down to forget, so Andy.
Thanks, Chair, and you'll be glad to know most of the points have been covered, so there'll not be too many for me to raise. Can I just pick up on the welfare reform easement, which is largely due to the lack of legislation? Can you just remind us, I think the budget, that's some 40-odd million for the mitigation package and the closing of the loopholes, what the makeup of that budget was again, please?
Yeah, there was 42.8 million that was allocated for welfare mitigations in the current financial year, and this included funding that we needed to close the loopholes in both social sector size criteria and the benefit cap mitigation schemes. The estimated total cost of benefit cap mitigation in 21-22 was 5.5 million included in that original requirement. This included 3.5 million for closing the loopholes. Yeah. Additionally, as well too, there was expenditure factored in for closing the social sector size criteria loophole. It was a lot smaller at 154k. Obviously, you'll be aware then we have surrendered 2 million in the monitoring round. The department is still progressing the necessary legislation to extend the mitigation schemes and close the loopholes. At this point in time, I don't have confirmed dates for that, but the department will update committee on this at the earliest opportunity.
Appreciate that. And just in relation to the fuel poverty, and I appreciate I'm going back over old ground, it's already been raised, but is there a commitment that the department will bid for the full 14 million, albeit unhypothecated, but will the department bid for that full amount?
The options are still being considered, and obviously Minister will take a decision on that in due course.
Is there any more detail on the options that are being considered? Are we likely to see something similar to the COVID heating payment, or are there different considerations on the table at the moment? I'm sure, given what we've seen in relation to fuel poverty over the last number of years, the department must have a number of considerations.
Yeah, there's a number of things being considered. Obviously, last year that we had Warm Well and Connected within the department, there was the whole COVID heating payment. Obviously, too, there's the opportunity to consider discretionary support. So there is a range of options being considered about how that could be delivered, and committee will be updated in due course.
And it'll come as no surprise, sub-regional, there was no consideration regarding sub-regional, obviously because it's not in there, but we're still not at the stage to roll out sub-regional.
So at this point, no, there's no bids in October monitoring. The Minister is committed to delivering the programme, and once she's considered all the evidence and benchmarking and research information available, and is satisfied that reflects the needs, she'll present proposals to the Executive on the way forward, including the timeline for the delivery.
Thanks, Gavin, Cherry. I do have a number of questions in relation to the 55 million uplift, but it's unfair to ask them of yourselves because they are policy related, so I'll table them to the Minister. Thanks, Chair.
Okay, thanks, Andy. I know, following on from this, certainly I've penciled down here, we've got the UC uplift, the fuel poverty payment, and also that the ongoing housing options. I think there are 3 briefings that we certainly need to have the department in to brief us on. And Anna's quite right, it's not fair to ask you two all of those questions because you'll not have the answers to them. But I think that is something following this briefing today that we need to be asking the department to come in and brief us on. Certainly those 3 options to start with, but if there's any more members want to identify, then we can do that. Is that you finished, Andy? Yeah?
Yeah, Chair, thanks.
Okay, can I then bring in Mark, please?
Thank you, Chair, and thank you to Cherry and Gavin. You just sort of stole my thunder there a wee bit, Chair, in terms of your proposal. We certainly do need an urgent briefing from officials on this, particularly around the 55 million. We need full clarity on the legislation that is required, how that can be passed, and what mechanisms exist that can maybe be utilised to get money out to those who desperately need it in the interim. You know, we have seen emergency legislation used here in the not too distant past, and in my view this constitutes an emergency for 134,000 claimants, or at least a good proportion of them. But we're extremely pleased to see this bid, and will be very happy to support it. In terms of the easements, I don't think there's any huge shocks or surprises in there. Just in terms of the UC staff recruited, I think you said, Chair, there was 600 in place, and that's 240 short of where we wanted to be. Is there any indication or anticipation of when those other posts will be filled?
Yeah, there's, and this was at the earlier in September. There, at that point in time, there had been, was it over 200 other offers had gone out, and pre-appointment checks were being completed on staff. So we are hopeful we will have the full 1,000 staff in place within the current financial year.
No, that is good news, and well done, because I know it was late getting started, but you have done your best, or the department has, to catch up. See, in terms of and then with regards to the lower than expected contract costs, Kelly asked what they were. Could I ask why they were?
As a result of contract negotiations by the department. Also too, we were holding a level of budget until the contracts were agreed.
Okay, and just one more one, and that was on the supporting people, the easement or underspend of the 550 there on PPE. Would there be any way that money could be kind of retained within supporting people? I don't know, even if it was around COVID protection friendly physical improvements and some supporting people projects.
That funding was ring-fenced purely for the PPE, and therefore, for that reason, it has had to be given back to the executive to redistribute.
Yeah, no, I was conscious of the PPE element, but I was just wondering what flexibilities might exist even within that, in the context of COVID, expenditure possibly on physical improvements, like say, that would maybe tick the box as being in line with COVID protections, but will ultimately add value, effectiveness and safety to premises where some supporting people projects are delivered and their staff and service users.
Well, certainly the funding that was there was provided where possible to manage all protections that could be put in place for those providers. So at the spend to the end of August was 110,000. So really at that stage, we couldn't forecast the full amount being spent. So it has been given up as part of Victoria Monitoring.
And then it's just going back to the 55 million, and that's brilliant news. Like I said, it's been bid for, and hopefully that bid will be approved by the executive. But in the interim, we've touched on legislation in it, but are you aware of any mechanism through which payments might be able to be issued to people in the interim? Andy had mentioned there the COVID heating payment, and
we look at school meals, and that wouldn't be everyone, but I do think we have to be as creative as possible here to minimise disruption and minimise hardship to people.
Yeah, we are aware that there are mechanisms that would allow that to be delivered. It's just obviously getting those all in place, and there's obviously a period of time just to ensure that can happen. So the department would be confident that they could do this. Again, obviously the timing of that is slightly uncertain at this point in time, but happy to brief as we obviously understand more on how we will do this.
Brilliant, Jane. Thanks a million. Thank you.
Thanks, Mark. Paul?
Yeah, I came in this morning in a very good mood, and then I realised I didn't have the information in front of me to thoroughly scrutinise in this committee the work that you guys are doing with regards to the bids, because I only received it from a staff member here at 10:44. I note the letter was dated the 6th of October, which was yesterday, and I share the concerns of the chairperson of this committee and echo her sentiments. It's simply not good enough that I as a member of this committee, scrutiny committee, is only receiving important monetary round data minutes after meeting you guys. It's just not acceptable, and I start there off in my questioning around that, because I am pretty much blind as to what we're actually discussing here, and I've only had a few minutes to go through this paper. It is unacceptable, totally unacceptable, but we'll try our best. Can I talk about the 55 million you've bid for with regards to the universal credit uplift? And I know it's topical at the minute, but surely this is only half a bid. What is the point of bidding to the executive? And to me, it's quite unfair to the executive that you bid 55 million, which is the amount of money you know has to be drawn down to support people, but yet you make no bid with regards to the operation and the actual delivery mechanism to get that money down. So in effect, is it the case that you bid for money, but you have no mechanism to spend it?
No, so the 55 million bid has been met to cover costs to the 31st of March this year. We've also notified Department of Finance of the recurring requirement for 108 million next financial year, increasing to over 200 million with the move to universal credit. We've also alerted Department of Finance to the fact that we will need additional funding for the staff and the IT, and that we plan to submit a bid for that in January monitoring.
So if you get this money, and we know that this has always been a temporary measure by Westminster Government, so we knew by the very nature of it being temporary, we knew it was going to come to an end. Now we can make a policy decision here, the Department or the Executive or the Assembly for that matter, that we continue this cost. But you bid for the money of 55 million, which is the amount of money, and the 108 million per year, which could increase to 200 million. But there's nowhere in this evidence here that gives me an indication as to how much it will cost the department to actually deliver the 55 million down into the hands of the people who need it. So my question is, why are you waiting to January to bid for that? And why has that scoping exercise not been delivered sooner, knowing that this has always been a temporary measure?
As I said, work's ongoing, obviously, to confirm the delivery mechanism for this. And we have notified DOF of the fact that a further bid will follow in January monitoring. At this point in time, we couldn't confirm the cost of that.
So when did that scoping work start?
It's started recent. It's just started recently.
Last week, this week, a month ago?
I can't confirm on the policy side for dates.
Maybe we could find that out. Do we have any ballpark figure as to how much the mechanism delivery will cost, given the fact that we do hand this money out to the people who require it in a general sense? So adding that £20 additional, do we have any indication as to the different mechanism mechanisms we will require in order to deliver that £20?
That information is currently being collated within the department.
So what we're saying here then is the department has bid for 55 million of the executive, but we still do not know how much the executive is going to have to pay to deliver that 55 million. So you've basically put in half a bid to get this money onto the ground for the people who require it.
We've notified Department of Finance that we will submit a further bid in January monitoring for the cost to operationalise.
Yeah, and that's what it says in the paper. So we know that this money has stopped now. So how is the department going to deliver this money before January monitoring round if you're successful in your 55 million bid?
We can, if there's any additional costs, we can obviously approach DOF sooner if there's a requirement for additional funding. But again, we'll pick the full cost up as part of January monitoring.
So there's no. So if you get this 55 million, we're saying that whenever we find out the cost of a delivery, that you're going to go to the Department of Finance in between monitoring rounds.
We can alert department.
What mechanisms are in place to allow that?
We have regular meetings with Department of Finance on a monthly basis. Again, too, we have the opportunity to go to them at any time and can flag at any time a pressure emerging within the department.
And they can freely hand over money to a department in between monitoring rounds?
No, it will still require executive agreement.
Okay, so you still have then executive agreement. So are we saying that scoping exercise to find a mechanism to deliver this money will be completed next week, next month, or beginning of December? When will that scoping exercise be finished, completed, so you know the cost of delivery, which then means you can go to the executive and ask for that additional money?
I don't have dates on that. I'd obviously need to refer to policy and operational colleagues.
So again, where are you finding the money? Where are you finding the money now, even before the 55 million bid is accepted, but even if it is accepted, and before you get that money from the executive, how are you getting that £20 into the hands of the people who require it?
Work's ongoing to determine the delivery mechanism and will be subject to obviously the executive agreeing that it can fund the 55 million this year.
I'll leave it there, Chair.
Okay. I suppose the worry is, from what you're saying as well, that and the staff costs around this, and we're looking at the January monitoring round. I suppose that flags up a worry as well. Will we be waiting until January for this money to be rolled out, or is this to be rolled out sooner rather than later? And I know you maybe don't have the answers on that. So again, I think that's why it's important that department come in and brief us on this next week and let us know exactly what their plans are. You finished with that?
Yeah, thank you. Chair.
Okay, can I bring Brian?
Thank you very much. I'm still trying to work it out in my head where Paul agrees with the £20 being given to people or not. You know, he was blowing hot and cold along the way, because I actually think the Minister should be congratulated for moving quickly to try and get the £55 million as a start. As people, I think Mark Durkin had asked, it was the initial question that I was going to ask, and that was regarding recruitment and what was the mechanism used to try and recruit people. We still hadn't had 240 people. Obviously, we have to look at the capacity within the department of delivering £55 million rather than going away and looking at other mechanisms. And I think that would be the first port of call, because that's where the expertise is. That's where the people who had delivered the £20 up to now. And I think that's important. And if you look at not only the monitoring round, but much of the minutes that we deal with in relation to ministerial, the money's being given out, that a big lot of it has to do with poverty. And this £20 here is at the heart of the matter. If you watch the television or you listen to the radio and you listen to horror stories, so £80 a month could mean the families are, especially in the run up to thing. And we should all be looking at yes, the Paul is right, they asked the questions, but the 55 million and what that could mean to people out there who have lost it now. And I think that's the important point in this. In terms of monitoring rounds, I agree with you. I don't know, many times we've sat through minister after minister after minister. Some of them didn't even deliver monitoring round papers, sometimes months late. So you have that. The fact that the reasoning given is that they were trying to put together a bid for 55 million people, £55 million to deal with the difficult situation that has arose in around the £20 for universal credit. But to go back to the main point that I was saying that Margaret raised, has there been an analysis done? And maybe we can look across departments, because there was 240 jobs short here. How many job vacancies are there in other departments? And what mechanisms do we use to try and ensure that people have an opportunity to come on board? Because obviously they're required for these posts, but there could be thousands of jobs sitting there. And we need to look at another way, whether it's job fairs, whether it's dealing with a broader community sector, and there is to try and ensure that everybody's given an opportunity to be able to apply for these jobs.
Do you want to make a comment on that, around that, the delay in the recruitment of staff?
Well, the delay this year, obviously, it was impacted earlier in the year with the ongoing COVID restrictions. And we've continued to keep pace. There's very, very close working with NICS HR in relation to bringing the staff in. Again, as I said, close working. We'll be doing everything we can, obviously, to get offers out for the people, get them in post, and obviously commence the training that's required to deliver benefits.
Okay, thanks for that. And just to follow up then on what Fra was saying there as well, I mean, and Fra's absolutely right. The people that know best how to deliver work within our departments, if we have a shortage of staff, how is that going to impact on the delivery of what could be a new scheme or an increase in a fuel payment or tackling the fuel poverty? What impact, if any, will this shortage of staff have on any of those programmes?
Well, last year's fuel payment, we obviously a lot of the payments were delivered automated through the systems. And it was only a small number of mop-up payments then actually had to be manually processed by staff. So there is mechanisms in place that we could deliver something going forward.
And I know. Sorry, go ahead, Cherry. Sorry.
So obviously, as I said, there's a range of delivery mechanisms being considered on how we would deliver the 55 million. And obviously, there may be a period of time to put those in place, but the department would be confident we could do this.
And that fills me with a little bit of dread, because I remember the fuel payment scheme last year, and I remember as a constituency MLA and this committee that there were major problems in the delivery of that. And I know that strictly wasn't the department's fault because of DWP and those years that the Assembly was down caused issues. Are we satisfied that we have the staff there and the resources there to actually make sure that it's certainly less problematic this year?
Yeah. So there was I think there was obviously the COVID heating payment that issued, and it was done relatively smoothly. The issue with the normal winter fuel payments was because of a system change, and now that's in place and all system issues have been rectified.
That's grand. Thanks, Sherry. Andy, you want to come in again?
Yeah, Chair, I just want to come back to the UC uplift point, and I appreciate delivery mechanisms are still being looked at, and we'll get that briefing hopefully next week. Do you know, Cherry, if there's discussions with DWP, given that this was centrally delivered at the outset, to deliver it through that existing mechanism uniquely to Northern Ireland?
Yes, there's discussions ongoing with DWP, but at this point in time I have to say that options are being considered. And again, committee will be updated in due course.
Thanks.
Okay, right. Look, there's nobody else has asked any further questions. Can I thank you both, Cherry and Gavin, for coming in and briefing the committee today. And I understand some of the questions you wouldn't have had the answers for because it's not within your gift to have those answers. But certainly, thanks for the update. Thank you.
Okay,
Thank you.
Okay, bye-bye. Okay, members, then can we then just get that down then, that we propose that certainly the UC uplift, we need a full briefing from the department on that. We need a briefing on the fuel poverty payment and how that's going to roll out. And we also, I definitely want one also on the increasing housing option. Because we will see as we go into this winter further people in difficulties when it comes to paying rent, paying their mortgages. There will be added pressures put on that whole homelessness as well. So it's important that that scheme gets going ASAP. Andy, you wanted to come in then,
Sure.
Kelly, then Fra.
I have 2 points really. The first point being in advance of the briefing on UC, and I think collectively around this table we'll all welcome interventions to support the most vulnerable across our society, but there are concerns raised from that in terms of the delivery mechanisms and how that's going to be funded. If the department can provide us with a written briefing or written information of any sort to outline what delivery mechanisms they're considering, ideally, this would be delivered through the existing universal credit system. It's already in place. UK government already had a system in place. We already have deviations in terms of our payment frequency in our universal credit system. So could that be the delivery model? Certainly would be the delivery model that I would suspect the department would be preferable towards. And on another issue, if the committee's agreeable, I would like a briefing on sub-regional, because the Minister stated that they've done all of their assessment, etc. now, and it's up to the Minister to consider where we are. In advance of the January monitoring round, I would like to know what the requirement will be to deliver sub-regional before the end of this mandate.
Okay, Andy,
or at least start it, sorry.
I think when we get that options paper on the universal credit, I know Fra and I sat here through the old welfare mitigations or welfare reform bill, and just the problems that DWP will put in or did put in the way then, and will continue to put in everybody's way on any deviation of their computer system, because there's a cost associated with that, so that will give us an extra cost on top of that as well. So all of those costings which have not been clear, we need to get that, and also then yes, and certainly the sub-regional, we can ask for a briefing on that. Kelly, you wanted in, and then Fra.
It's just about that deviation piece, not on the computer system, but the actual money then that Northern Ireland will be paying to people who are living in poverty. We have to know from the department if that's going to be discounted against what benefits they receive, because to be honest, if it's not, then what's the point in us doing it, because they're just going to get it taken out of their universal credit payments anyway. The other thing is, I would love to hear from the department. Cherry has piqued my interest there. At the end, there appears to be discussions or something going on in the background. The committee needs to help. We're a scrutiny committee and we support the Minister. There's 2 rules for us here. If the Minister or the department's coming forward with something beyond March, we need to know about it, and we also need to know if it's going to be in time for consideration for the multi-year budget. So there's a lot there. I agree with you, Chair. We need to get a fuller briefing from the department on this, not just the budget, the finance people, as much as they have given us today, but there's a lot of questions there, so we can make sure that whatever system going forward and the budgets going forward are correct for people out there. The only other thing I would say is I think it is time that we ask the Minister. We've had the recommendations to the anti-poverty strategy from the expert group. We need the anti-poverty strategy, because if we are to effect change and deal with poverty, the Minister's strategy will help across all government departments to ensure that investment is made to reduce, if not eradicate, poverty in Northern Ireland.
Thank you for that, Kelly. Fra?
Sure, just a short one is regarding the welfare mitigations. And could we also include in that briefing what is the delay in progressing legislation to close the benefit gap?
Yep, absolutely. I know that, I think that's going to the executive today.
Yeah.
So hopefully we'll hear something on that later as well. Yep, we can ask those questions also. Anybody else want to make comment before I move off this agenda item? Nope, we're all okay. All right then, I want to then move on then, members, to agenda item 10, which is SR 2021-2 272, Occupational Pension Schemes Administration, Investment and Charges and Governance Amendment Regulations, Northern Ireland 2021. Excuse me, you'll find this at page 70 of your meeting pack. Can I ask members, have you any objections to the rule? Nope. Okay, then I'll put the following: that the Committee for Communities has considered SR 2021-272, Occupational Pension Schemes, Administration, Investment and Charges and Governance Amendment Regulations, Northern Ireland 2021, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Then we're going to move on to agenda item 11, which is correspondence. You'll find the correspondence memo at page 150. Can I draw your attention to page 180, which is a request to attend the Housing Rights Private Rented Sector Conference on the 24th of November. Can I advise members to reply directly if they wish to attend? I think I've been invited to that as chair of the committee, possibly, or I've been invited anyway. I hope to attend that. So I do, and it will be useful. Certainly, whenever we start our private tenancies bill on the Tuesday mornings after recess. So any member that can attend would be worth going. Members, also then, if you could turn to pages 199, there's a memo from the Clerk on Standards and Privileges Committee on its inquiry into legislative consent motions. The committee had previously made comments on the use of LCMs back in October 2020. I'm just going to read over what our comments were there, especially for our new members here as well, and just ask members after that if they have anything further they want to add, or are they content with our original response. So we had put that the committee has some concern about their overuse. It feels that their use should be based on necessity and not on convenience. The committee proposed that the department or minister should clearly demonstrate the need for the use of an LCM, and suggested that this could be accomplished through an accompanying statement or rationale. And the committee felt that it would be very useful to know, as far as in advance as possible, how many LCMs departments are planning to introduce, in order that it can devote sufficient time to scrutinise them properly. So that was back in October 2020. Members, have you anything further you wanted added on to that in relation to LCMs? Are you happy or content that our original submission will suffice?
Can I ask you, have we asked the question? Sorry, you want to go ahead first?
No, Paul, work away.
Have we asked the question, and again I'm coming to this fresh, have we asked the question of any LCMs that the Minister isn't prepared to bring forward?
Isn't prepared?
Yeah.
Okay. Well, I don't think we have asked that directly.
There's maybe none in ether.
Yeah.
There's maybe none there.
Yeah.
If I'm right in saying an LCM is whenever a Minister brings that instrument to bring forward a piece of legislation from Westminster. So there may be occasion whenever a Minister doesn't agree with a piece of legislation from Westminster, so she would then refuse, or he would then refuse to bring an LCM forward. So it's just in case there's a blind spot there with regards to any LCMs that the Minister's not prepared.
I know we haven't had many recently. We did have a few last year at the beginning of committee and during COVID, but there haven't been too many of them quite recently. I have Onion, then I have Mark wanting to come in.
No, Paul had just touched on my point there. I just wanted to double check, was it Procedures Committee or Standards and Privileges? But I'm just after seeing it's Procedures here, Chair.
Okay, hold on. Clerk of, are you talking about, sorry, the memo or what?
Yeah.
Standards and Privileges, is it?
Yeah, I was just going to declare if it was an interest I sit in that
Okay.
committee as well.
Not a problem.
Just to keep
No
us
bother.
right.
No bother at all. Mark, you wanted to come in?
No, thank you, Chair. I wouldn't change anything about the letter. I mean, I think all parties around the table at the time, and I'm sure still would, express concern about use or certainly overuse or abuse of this mechanism. I was just wondering, could we maybe get it quantified? I know you quite rightly, Chair, by my recollection, says yes, we did have a lot, but they seem to have reduced it to a trickle now. But just to see how many times it has been used by this department or minister, I think, and when. because I think now we were front loaded with a lot in this mandate because of, when we finally got this mandate started, because of the 3-year vacuum and the amount of catching up to do, so as not to leave people living here in Northern Ireland lagging behind in many areas.
No, well, I mean, if members are content, first of all, then that we just don't add anything further to this and send this through to standards and privileges. And then the other option there that has been mentioned by both Mark and Paul is to ask the department how many that we have gone through and suppose the dates. So those, and you're quite right. I remember we had loads of them at the beginning of this mandate because of decisions that have been made in Westminster and needed to be rushed through quickly. But it also is an interesting point Paul made. Are there any that the Minister, was against bringing forward an LCM? So we can ask those questions. Members, is there anything else in correspondence members want to bring up? Kelly, did you want to come in?
I was going to actually say, Chair, about the correspondence we've received from Pivotal on page 152. I know we're up to our neck and they have provided a link, but given the fact that we have the, what is it called now, Job Start scheme coming forward and the number of young people who have been impacted by unemployment, is it worthwhile us even getting a stakeholder event with people like that at some stage? I know we've got a lot of bills coming through, Janice is looking at me, but it would be useful to have just with our considerations. And then I was going to ask the Shield Us, which is at 194, should we forward that to the Minister for Education or the Committee for Education to get their response? Because it does talk about COVID guidelines for schools. Yeah,
we can certainly forward that through, and I think you're right to do with the Pivotal report. We will maybe then try and set up some sort of stakeholder event to look at those issues. No, that's fair enough. Good points. Anybody else? Mark, you have your hand up still, or don't know if you want to come in?
Oh no, sorry, Chair, just forgot to put it down.
No bother. Anybody else want to raise any issues then on correspondence? Okay, can we agree to the correspondence memo as amended? Members agreed? Yeah?
Agreed.
Yep. Dead on. Good stuff. Moving on then to agenda item 12, which is our forward work programme. Next week's meeting we will be briefed in closed session by the independent review panel on the Charities Bill. The closed session is to allow them to answer the committee's questions in full and as openly as possible ahead of their findings and recommendations being made public. So as that hasn't been made public yet, I think it's members agreed then that we do that in closed session. Yeah. And we'll also be briefed by Social Enterprise NI. So yeah, that's where we are for next week. So members happy enough with that, Kelly?
Sorry, no, sorry, is there any other business?
All right, okay. I'll move on then to agenda item 13, which is any other business, Kelly.
I was just going to ask, can we write and ask the department for an update on, now other members can keep me right on this, there was funding to be made available to councils, or councils could apply for changing places toilets, to see what has happened with that, how many councils have applied, and if that we had asked before, I think, about another prompt to councils who hadn't applied to do so, where that is.
Okay, yep, certainly we can ask that. Any other business members want to highlight? Okay, then we'll move on then to agenda item 14, which is date, time and location of our next meeting. Our next meeting will take place here in room 29 next Thursday, the 14th of October at 9 a.m. Thank you, members.